Howdy, my name's Brian Foley. I'm a criminal defense lawyer in Conroe, Texas, and I represent folks who've been accused of a crime in Conroe, the Woodlands, Houston, and that general area. Today we're going to be continuing our lecture series on the Texas Rules of Evidence. Today's rule of evidence is Rule 403. It's one of the most important rules. Lawyers, we will frequently refer to this rule as the more prejudicial than probative rule. That's technically not correct. Let me read you the rule here. So the rule says 403, excluding relevant evidence for prejudice, confusion, or other reasons. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, or needlessly presenting cumulative evidence. So, this is the objection. You may have heard this. Judge, objection, this evidence is terribly damaging to my case. That's not a very good objection. Much better objection, which is the same objection. Judge, this is substantially more prejudicial than it is probative under Rule 403, right? When the other side is doing something that is going to annihilate you, but it's really not fair the way they're doing it, this is your objection, right? If there's some terrible skeleton in the closet of your client and it really doesn't have anything to do with the facts of the case and whether or not this particular case was committed, or whether this offense was committed, well, you're probably going to have an objection under 404 for improper character evidence. But you may also have an objection under 403 that it's substantially more prejudicial than it is probative. So put into English, right, this means the thing that they're trying to enter into evidence is really, really hurtful and not all that helpful, right, in deciding the main issue of the case. The Court of Criminal Appeals, the highest court for criminal cases in Texas, said there should be a clear discrepancy between the degree of prejudice of the offered evidence and its probative value. Clear disparity, right? That's what they're looking for. It's got to be bad. That when you're trying to argue under 403, if it's a close call, we're not going to get there, right? It's something that the court is going to basically try to not exclude the evidence. And this is a change from the common law. The reason why lawyers typically call this the more prejudicial than probative rule is because that used to be, in fact, the law. If the judge decided that it was at all more prejudicial than it was probative, well, then they could exclude it. Now the test is substantially, and it kind of pulls the rule back a little bit. It allows the judge to let more evidence in, and so that the jury can make a decision. You may have also catched this. There's a may and not a shall. So even if the judge determines that it is more and substantially more prejudicial than probative, they still have that option under the case of Powell versus State, 189 Southwest 3rd, 285, Texas Court of Criminal Appeals in 2006. It means that the evidence, even if the court believes the court could exclude that evidence, again, even if it was undue delay, they could allow and admit the evidence in question. So that means if, let's say I'm one of the lawyers, right? And the other lawyer is taking an incredibly long time and it's really disrupting the proceedings, it is not reasonable to take this much time to present certain types of evidence. Or maybe they're presenting evidence over and over again in a cumulative fashion. The judge could agree with me, say that they're in the wrong, that they're wasting everyone's time in a way that's not fair, and they could still allow them to continue. And, most of the time judges are trying to avoid making a ruling because they want to do what's called protecting the record. And protecting the record means if the case gets appealed, they don't want it overturned on appeal. This is probably a good time to mention this rule when there is evidence excluded under Rule 403 or that's not properly excluded under Rule 403, then the court is going to be judged on an abuse of discretion standard, which is a very difficult burden to reach on appeal. So pretty much the trial judge gets to make the decision here. Let's go into some examples now. The Texas Court of Appeals for Fort Worth ruled that it was unfair to allow the testimony of a murder victim's character for making people angry just in general. That was in Dickens versus State, 760 Southwest 2nd, 374. A very famous case here that you need to know is Old Chief versus United States, 519 U.S. 172 from 1997. That is the case that says evidence of a prior conviction cannot be admitted when it has been stipulated to by the defense. So this often comes up in Texas in DWI third trial. So if it's a felony DWI, you already have 2 prior convictions for DWI. That's what makes it a third-degree felony. Unless you have a child in the car, then your first time is going to be a state jail felony. But let's say we're at a third-degree felony, DWI, you got 2 prior convictions. Well, the state has to prove those convictions to prove the jurisdiction. If you do not stipulate as the defense to those prior convictions, then the state gets to offer the videos. They could bring the police officer in to testify about who it was that they pulled over that day. They don't have to just limit themselves to the judgment with the fingerprint on it, that they're likely to have. They could actually bring up what happened in those old cases. Well, because that would be more prejudicial than it is probative of the fact that you committed a new DWI, you can stipulate to those crimes. And that's what the Old Chief versus United States case says, is once you stipulated, it really is not probative of anything, because the only thing they have to prove is that the convictions happened, not how they happened. I hope that makes sense. Here's another one. Evidence that 4 states' witnesses were gang members. That's from Barlow versus State, 175 Southwest 3rd, 839. The courts have also ruled that it's not unfair to enter a defendant's parole status as a motive to throw the gun out of a car. That's a good one to talk about. That's Powell versus State, 189 Southwest 3rd, 285. The reason that one's good to talk about is because it kind of relates to this next rule, Rule 404. That's going to be a good example of Rule 404 exceptions to when something that's generally bad character evidence, it's more prejudicial than it is probative, it all of a sudden gets lassoed back in and allowed into evidence because it relates to motive. So in the Powell case, they charged him with tampering with evidence for trying to hide a firearm. And, the defense says, well, no, he wasn't trying to hide it. He didn't do this, whatever. Well, then the state gets to come back and say, in rebuttal to that, the motive for him trying to hide this is, well, he's a felon, right? Or he's, he was in a gang and, or something like that. So they'll try to use those bad character reasons and bootstrap them in under Rule 404. And so when you make an objection to the state doing that kind of stuff, you have to make the objection. I would always make it under Rule 404 and Rule 403. Here's a case, interesting case, Thomas versus State from Houston. And the court said that it was error for the court to refuse to allow cross-examination of a prior rape allegations made by a current victim. So that means, could a defense attorney say, hey, you have reported, rape before, maybe untruly, and I want to talk to you about that since you're reporting it again. That was denied by the trial court judge, but the appellate court found that it was error for the court to refuse that and deny it under Rule 403. Well, that is today's rule. I hope you've enjoyed it. Make sure to click that like button and click subscribe as well. Turn on notifications so you get all my new videos. And we'll see you next time. Thanks so much.